Hello, ladies and gentlemen, and thank you so much for completing the journey with us. And we still have one more fabulous presentation to go. And I think it's really important because we are the Center on Law, Ethics, and National Security. And we're going to hear a real expert talk about those things. And I'll tell you, Tim, I've kind of known Tim from his writings and some other things. But this is the first time I really focused on his bio, and he's scary smart. You know, he was summa cum laude from Creighton with a Bachelor of Science in Mathematics. Okay, one of the reasons I'm a lawyer is mathematics, and that's not because I was good at it. And he graduated cum laude from Baylor School of Law. He also has a Master's of Law degree in cyberspace and telecommunications law from the University of Nebraska. He has a Master's of Arts in Operational Military Art with highest distinction from Air Command and Staff College. And he is a professor, a senior military faculty and assistant professor of law at the United States Air Force Academy. Tim, it's so great to have you here. Without further ado, let's get started.
Well, I'm either your favorite speaker or your least favorite. I'm either the person standing in your way, getting home, or I'm the person who is bringing clothes to this wonderful conference. Either way, we are in it for the next hour together as we figure out how to get this professional responsibility hour, or as the lawyers call it, our ethics CLE. First of all, I'd like to thank General Dunlap for inviting me out here. I'd like to thank Joy and General Dunlap for the hospitality they've shown. It's been fantastic. And I'd like to thank Duke Law School for putting on this conference. It's been a pleasure for me sitting back in the speaker room watching all of the speakers and for meeting all the wonderful people that have spoken at this conference. Now, I thought it apropos for me not to write my own introduction, but rather have ChatGPT write it. I thought about giving it the whole speech, but I thought that might be a little too long. And after I read it, I didn't love it, so I asked instead, for a little bit of levity, I asked for a funny intro. So here we go, straight from ChatGPT. Ladies and gentlemen, welcome to today's lecture on the legal professional responsibility issues with cyber and artificial intelligence. It's an exciting time to be a lawyer. Not only do you have to keep up with the ever-changing laws, but now you also have to keep up with the machines that are taking over the world. Just kidding, but only partially. With the rise of AI and automation in the legal industry, it's more important than ever to understand the ethical and professional responsibilities that come with using these technologies. In this lecture, we'll discuss the implications of AI and cyber technologies on the legal practice. So let's get ready to talk about robots, justice, and how to keep them from turning against us. So that's not bad, right? I also asked ChatGPT if it could tell me a funny AI joke. So let's see how this goes over. If an AI simulation of a pop singer performs all over the world, does that mean she passes the Turing test? Okay, that's a pretty good reaction. You guys gotta get it. All right. Yeah, for those of you that didn't get it, you know that the Turing test, named for Alan Turing of imitation game fame, is actually a test that we try to measure the ability for a computer to speak or to think for itself and to replicate what a human might do. And so if it passes a Turing test, then it meets this sufficiency. And so now you can understand the Turing, it's a play on, never mind. Okay, I'll move on. All right, so as ChatGPT mentioned, the world is getting more technological. And as the world gets more technological, I don't have to tell this crowd that computers are becoming more and more ubiquitous in military operations, at headquarters. Here, Attack P is actually testing the computer for we're calling in close air support. And as a result, the battlefield is similarly becoming a more technical one. The next step in this evolution is autonomous weapons, drones affixed to cameras that are able to not only identify targets, but also distinguish between targets and engage them. These weapons are powerful, and that's just the tip of the iceberg. Artificial intelligence, while being able to use as an autonomous weapon, also has the ability to train and test pilots on how to engage in dogfighting techniques and how to perfect them. It has the ability to make strategic recommendations, to actually sift through petabytes of intelligence, surveillance, and reconnaissance data, and identify targets and be able to select those targets and do an analysis of whether or not they are lawful. Artificial intelligence has the capacity to change the battle space in ways that we can't even imagine. And as the technology gets more and more sophisticated, how do we, as lawyers, advise on these new weapons of war? As lawyers, many of us spend our practice and even may stand up here at this stage one day and say that we are not mathematicians. We are not engineers. We are not programmers. And all I'm here to say to you all is that while that is true, we also have an ethical obligation to learn these technologies, to learn how they work so we can better advise our clients on their legal implications. And they tend to ignore us because they don't understand international law, or they don't understand the finer points of proportionality, precautions, or distinction. They often just want either a yes or a no answer. And as a result of this, a gap is created, a gap exists between the technical operators as well as the lawyers. And this is an unacceptable gap. We need to develop these capabilities with the law in mind. And the lawyers need to be there at the outset to make sure that the engineers understand international law and can bake it into the process from the beginning. We need the lawyers who can understand technically what's going on so that they can advise on how to make the technical ability or technical aspects of suites more legally compliant. And it exists outside of artificial intelligence, it exists outside of cyber, it exists within space, it exists within autonomous weapons, within quantum computing. Now, some of you might be saying, well, I'm the older generation. I don't need necessarily to understand these things. The next generation is coming along, and they have grown up with computers. They get this. So Colonel Goines, thank you for this, but it's about 20 years too late. I will say I've got news for you. Our generation and the generations that have come before me do not have a monopoly on not understanding how computers work. I work with undergrads at the United States Air Force Academy, and I can tell you that they know how to use a computer for the most part, but they don't necessarily have the interest to figuring out why they do what they do and how they do what they do. So I believe it actually applies to all generations equally. So my thesis today is that understanding technology is an ethical imperative for practitioners and policymakers in the realm of national security. In other words, we can't just keep our heads in the sand. And while the attorney doesn't have to be qualified to design the system, some familiarity with the technology will help them keep up with the conversation and be better lawyers. Now, I think you might all go with me on this. You're at this particular conference. You've stayed this far. So I hope you realize that technologies are important in understanding how technologies work. That said, in case you need reasons, I've got two for you. First, there's a practical reason on why you want to understand the technology. For example, if you don't know how a cyber exploit works, how would you be able to advise a cyber operator how to do it lawfully? What rules it has to comply with, or whether you could actually deduce if it complies with domestic, international law, or the authorities that have been granted to you. For example, the NotPetya attack, if you're familiar with this, this was a launch or an attack launched by Russia against the Ukrainian financial sector in 2017. It's considered to be the most devastating cyber attack in history. It was a piece of software that combined actually two hacks in one that would lock down a computer's master boot record. It sort of looked a lot like Petya, which is why it's called NotPetya, but it had one key difference. It looked like ransomware, and as you know, ransomware is a type of malicious code that actually locks down the computer, and then somebody has to pay a ransom to unlock it. Well, with NotPetya, there was no unlock feature, and as a result, it was there just simply to destroy the content on the machine. Now, the reason that it was so devastating was because it was indiscriminate. It was aimed towards the Ukrainian financial sector, but it actually went all over the world, from from a sweet or a chocolate factory in Tasmania to a hospital in Pennsylvania. And unlike other operations like Stuxnet, for example, the code made no attempt to distinguish between computers that were targeted, what we consider lawful targets, or computers that are not targeted. Now, admittedly, this was from Russia, and so maybe they had no interest in making it discriminate. That said, the lesson we can glean from it is the fact that a cyber operation can be absolutely devastating. And what we've learned in coupling with Stuxnet is that it can actually be discriminant. And it's up to the lawyers to be able to be there, to understand how it works, and be able to advise on it. And there's examples, that's just one from sort of the law of armed conflict. The examples in the civilian sector abound. There's a ton of them. For example, Snapchat. Snapchat was entered into a consent decree in 2014 with the FTC. It was all about whether or not your snaps remained private or whether they could be screenshotted. It turns out that they could, and they were being saved. And Snapchat advertised that all of them were disappearing, and as a result, the FTC entered into a consent agreement to basically say that was false and misleading. In 2017, Uber was settled with the FTC regarding allegations of improperly storing consumer data. I, as the lawyer, may understand the standard. The standard is to employ reasonable security measures to protect consumer data. But unless I ask questions, how are you storing that? What are the security measures that you're employing? I don't quite understand how I can best advise them. The job of the lawyer is to fuse the law with the facts to provide advice. And critical to understanding those facts is the technology. Facebook, most recently, had the largest FTC settlement in history, $5 billion, for repeated attempts or repeated violations of consumer data. Some of you might remember the Cambridge Analytica scandal. That was third-party consent to sharing data. There was an opt-in, opt-out agreement that it turns out Facebook was ignoring. Now, we are also at the dawn of artificial intelligence. And artificial intelligence is extremely powerful, but it's also extremely data intensive. And so as a result, the data makes a huge difference in how the AI is ultimately programmed and how it works. And so the FTC has expressed a lot of concern over the biases that exist within AI, the transparency of the data, the accuracy of the AI models, and finally, the security of the data. As a result of these dangers, you see the, where is it? Where am I? There it is. Yeah. As a result of these dangers, the Department of Defense actually recently released, I don't know why I have this big thing in the way, the Department of Defense released the 5 ethical AI principles, AI ethical principles, on how they will develop the AI. Included within those, we'll talk about later, is responsible, that they have to be equitable, they have to be reliable, they have to be governable. And within those, right after that, or more recently I should say, the Department of State actually released, they doubled down on that and made a declaration, a political declaration on the responsible military use of artificial intelligence and autonomy. Now, as a result, when you look at these are the examples that they have, as a result, what we can see practically is that attorneys have sort of a really good incentive to understand the technology to make sure that they can actually do a good job for their clients. But more importantly for this particular presentation, there's a second reason that you might be interested, and that's because many of you either are now or will be soon subject to the ABA model rules of professional conduct. Now, so as a result, what we'll do is we will talk about these rules, and then my job could be done, but I'm a good ethics advisor, and so as a result, I will provide you a little bit of tips and then dive in a little bit into the technology itself to help to do some building blocks or create some building blocks for you to understand as you press forward. Now, I hope this audience is one that has gone with me so far. You sort of acknowledge, yes, I get it, Colonel Goines, this is a good idea, so tell me where my duty comes from. And if that's the case, fantastic. Please sit back, enjoy, use these rules as a way to reinforce. If you are on the other side and don't think the actual duty exists, well, by all means, give me some time to try to convince you. In either event, if you're in either camp, I just hope you use the opportunity to to use these rules, to learn these rules, to then spread this message across the lawyer community that we cannot turn a blind eye towards technology, that we have to understand it in order to be good attorneys. All right, so let's start with the ABA model rules. Now, almost if you haven't been to an ABA ethics model rules sort of presentation, you might not know, but they always begin with model rule 1.1, competence. So not to be cliche, but we will also begin with competence. And if you read the rule on competence, it says a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Now, it's important to focus on that last section. Reasonably necessary, preparation reasonably necessary for the present representation. This alone should help you see that in order for me to be reasonably prepared and to provide the necessary preparation for representation, I probably need to understand my client and what my client's goal is. That said, the model rules were actually amended in 2012. They added comment 8 under the maintaining competence heading. And in it, it says, to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. Engage in continuing study of education and comply with all continuing legal education requirements to which the lawyer is subject. The part that I want to focus on is this, including the benefits and risks of associated with relevant technology. Now, we would all agree that comment 8 is clearly focused on the use of technology in the practice of law. This is sort of how you conduct your actual legal practice, from how you email to how you handle information, et cetera, et cetera. So it can go from anywhere from how you maybe store your information on a shared drive to who you email and how you email, to how to remove a kitten filter during a Zoom hearing. But there's no question that includes this knowing what security measures that you should actually employ and what may exist on a shared hard drive, potentially using a VPN, operating a wireless network, or even a client portal on your website. So this rule, no question, addresses that particular practice. But it's also been interpreted broadly by states to include things outside of that. Here, California state opinion said that legal rules and procedures, when placed alongside ever-changing technology, produce professional challenges that attorneys must meet to remain competent. What I want to focus on is when placed alongside ever-changing technology. In other words, there are practices and procedures, legal rules, that actually might be different as a result, and your interpretation of them might be different as a result of the new changing technology. Now, the court in that particular case, and courts that have interpreted, many of them incorporating this California State Bar opinion, haven't created a set of rules or a standard yet at this point, because they said technology is changing so much, it'd be very difficult for them to do that. But the answer here is what we should take from this rule is the fact that you should, at the very least, try to understand the technology that you're advising on, because it actually makes a difference. And you need to do that before you start actually providing the advice. Now, this particular rule, as I said, was adopted or amended in 2012. Since then, 40 states have adopted it. So nearly all of them, only 10 remain, the holdouts. And so here's an example. Here's where you can see your state and when it was actually adopted. You'll see California, they liked the rule so much they did it twice. Not really. In 2015, they did it through that state bar opinion, and then 2021, they expressed it. So this is an example. If you are not on this list, well, just know it's probably only a matter of time. When I started giving this brief back in 2016, that number was somewhere around 25. So it's increased quite dramatically. So that's rule 1.1. The second rule is rule 1.3, that's diligence. The rule states that a lawyer shall act with reasonable diligence and promptness when representing a client. If you don't understand the technology, usually this rule is always focused on that second part, the promptness in representing the client. It's all about returning phone calls and making sure you're staying in contact with them. But you also have to be reasonable diligence, right? You have to have reasonable diligence. And when you think about it, if you don't understand the technology, how do you know the things that you need to be diligent about? And how do you know the things you don't need to be diligent about? The next one is perhaps my favorite. This is Rule 2.1, Advisor. It says, in representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering advice, a lawyer may refer not only to the law, but to other considerations such as moral, economic, social, political factors that may be relevant in a client situation. This is important. Notice the rule is called advisor. It's not called like legal advisor. It's called advisor. In other words, the rule contemplates that we go beyond just seeing this simply being encyclopedias of legal knowledge, especially when law is literally at their fingertips. Our job is to go beyond the law. It's to give them sort of a more comprehensive view, taking in a lot of different factors and giving them advice, considering all those factors. And so when we think about all those different things, we probably want to acknowledge that understanding the technology and the potential implications of that technology absolutely falls into the ambit of being an advisor. Again, the job of the lawyer is to fuse the law with the facts in light of the domain they're operating in. But there's a comment within there, comment number 2, that says advice couched in narrow legal terms may be of little value to a client, especially where practical considerations such as cost or effects on other people are predominant. Purely technical legal advice, therefore, can sometimes be inadequate. Well, if we, again, purely technical legal advice would, for me to simply say, oh, well, it can't be indiscriminate. Whereas when I actually start to understand the technology, I could provide real meaningful advice. It's the attorney's job to advise, to dive in, understand how it works, and see what kind of implications exist. Now, some of you might be saying, but what if my client only asks for narrow legal advice? As in, they just want to know the rule, they will apply it. And those clients do exist. It's fascinating. The rule actually addresses that in comment 3. It says a client may expressly or impliedly ask the lawyer for purely technical advice. When such a request is made by a client experienced in legal matters, the lawyer may accept it at face value. But here's the key. When such a request is made by a client inexperienced in legal matters, however, the lawyer's responsibility as advisor may include indicating that more may be involved than strictly legal considerations. In other words, you have an obligation to get a sense, to gauge your client's ability to understand not only the legal advice, but also the potential other considerations that might exist. And in doing so, you have an obligation to inform them if you don't believe that they are aware of those other issues. These may include legal and policy considerations. They may include moral and ethical considerations, but unless you know the technology, you will not know whether these other issues are implicated. Now, those 3 rules by themselves would probably be good enough, but never one to settle for just good enough. I will go on. There's another ABA rule that indicates that you need to be technically competent. Model Rule 1.6a, confidentiality of information. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. Now, we all probably are familiar with this, attorney-client privilege. For this brief, I think what we're sort of focused on is the idea of these leaking of potential emails or information through a computer mechanism, right, through technology. What's interesting is that the standard is that an individual that you have to exercise reasonable care. It's universal in all states that have addressed it. When they've interpreted it, they say, well, determining whether or not somebody leaked information through, let's say, a computer system, we look at whether or not they exercise reasonable care. And what do we mean by reasonable care? Well, fortunately, we have another California ethics opinion, seems like they're on the forefront of this, from 2010. And it actually articulated 9 different, it's a bit of an eye chart, 9 different factors that you would consider when determining whether or not an attorney exercised due care, reasonable care. And so, for example, the nature of the technology in relation to traditional counterparts, right? Sending in the mail versus email. And so they would say, well, it's normal for you to expect the same amount of security with mail as you would with email, and so therefore it's more reasonable. The one I want to focus on is this 4th one, the lawyer's own level of technological competence and whether it's necessary to consult an expert. In other words, you don't get a pass because you don't understand computers. Right? You don't get a pass to say, well, I don't know what a VPN is. I've never done it before. Why would I need to do that? The actual state bars have put an onus on you or an obligation on you to actually figure it out. And if you don't or you can't figure it out, to go hire somebody who knows what they're doing. Okay? So the state bars and the ABA are not taking this, or they're making this matter pretty clear. They're not taking it lightly. They're saying you have to get technical, right? So those are the ABA rules. Now, we're also here at sort of somewhat of an international law conference, and so I wanted to bring some international law into this. There's also another area of international law that does give rise to this potential issue, and that comes from the Talon Manual. Now, one disclaimer on the Talon Manual: if you've ever studied it, understand the Talon Manual is merely sort of a distillation, if you will, the lex lata of what the law is currently. It is not actual international law itself. But I use it partially because I think it's helpful, it's a good distillation, but also because of its obvious tie-in to this particular presentation of cyber. And so for you students out there, I'm not saying the Talon Manual is international law, but it is a good articulation of it. Okay. And so in this case, I want to focus on two Talon Manual rules. Rule 85 is the first one. It's the articulation of command responsibility. It says, the summary is simply that commanders and other superiors are criminally responsible for ordering cyber operations that constitute war crimes, which is pretty much an accurate distillation of what the law is. That said, Note 10 actually says, the technical complexity of cyber operations complicates matters. Commanders or other superiors in the chain of command cannot be expected to have a deep knowledge of cyber operations. To some extent, they are entitled to rely on the knowledge and understanding of their subordinates. Nevertheless, the fact that cyber operations may be technically complicated does not alone relieve commanders or other superiors from the responsibility for exercising control over their subordinates. In all cases, the knowledge must be sufficient to allow them to fulfill their legal duty to act responsibly to identify, prevent, or stop the commission of war crimes. Now, so the rule acknowledges that this is a complex area. Technology is complex, and cyber operations are complex. But the commanders have to have technical competence, at least sufficient enough to know when it could potentially be a war crime. And if the commander has the responsibility, shouldn't you, as the advisor to the commander, have that same or similar technical competency? Or at least enough that you can talk the same language with the commander? Another rule from Talon 2.0 is Rule 110, the summary of which articulates the customary international law provision of a weapons review. So the summary is cyber weapons must be reviewed for compliance with international law. Now, again, Note 9 provides a little bit of guidance for us. The determination of the legality of a means or method of cyber warfare must be by reference to its normal expected use at the time the evaluation is conducted. Any significant changes to the means or methods necessitate a new legal review. So that means we have to potentially look at every cyber operations twice. First, when the weapons review is being conducted. And when you conduct the weapons review, you need to be able to understand the means and methods, how it's actually operating, to be able to review whether or not it is legally permissible. And second, you also need to have enough know-how on the technology to understand when it changes so that it necessitates another subsequent legal review. So I believe that these 6 rules taken together give rise to an obligation, a duty that all lawyers must comply with, or at least the ones acting in national security. And so here is essentially my thesis. To be competent as a national security law practitioner, you must maintain a working understanding of the relevant technology and its advancement in the relevant domain. In other words, you have to get educated on the technology. This includes other domains, both space, cyber, land, as well, air, as well as other methods of warfare to include autonomous weapons, artificial intelligence, quantum computing, and the like. Now, I do agree, it is a big ask. It might not be in your wheelhouse, but it's not unfair, and it's absolutely necessary for us to be good attorneys. Now, as I said, I could stop there. I mean, it would be an okay presentation. I'll let you be the judge then. But I'm going to keep going, because like I said, I am a full service ethics, and we've got some time remaining. Now, what we're going to do is now we're going to walk through some steps, some tips, if you will, on how to actually fulfill your duty. And I have a 5-step process. Tried to get to 12, couldn't. A 5-step process on how to fulfill your duty. And so let's walk through these together to figure out exactly sort of a method you can use to become a good national security attorney. First, you want to understand your client's goals. So step one, understand your client's goals. Understand what they want to do and why they want to do it. What does that mean? Well, you probably want to understand the mission, right? That's probably your first goal. Understand the mission and what the client wants to do. How can you do this? Well, in the national security realm, or at least in the DoD, the first step is to read the relevant policy documents. Those include the DoD, right? In the DoD, we have the National Defense Strategy, we have the DoD Cyber Strategy, the National Security Strategy, the National Military Strategy, the Cyber Deterrence Strategy, and all cyberspace operations and all classified regulations. So we want to read all of those things. Why? Because they help you understand the larger strategic goals of your leadership. Okay? And once you do that, then, so there's the National Cyber Strategy. In the AI realm, we've got the 5 principles. We talked about that: responsible, reliable, equitable, governable, and traceable. We also have DoD Directive 3000.09, was just re-released, and it's all about autonomy and weapon systems. So you probably want to read those relevant things in order to start to understand exactly what are the things the DoD is focused on. When it comes to responsible, or when it comes to those 5 principles, responsible means remaining responsible for the development, deployment, and use of capabilities. So in other words, somebody in charge. Equitable means we want to minimize intended bias. We'll talk about unintended bias, I should say. We'll talk about that later. It has to be traceable, which is we want relevant personnel to possess an appropriate understanding of the technology. This is sort of a bonus rule. So if I had a rule 7, that would sort of say that you need to be involved. This is a good one, right? You're not going to work on AI unless you understand the technology and understand the development process and operational methods implicated. Reliable, we want it to be subject to testing and assurance that it's actually doing what we say it does. And finally, governable, the ability for it to detect unintended consequences and to be able to actually disengage it if we need to. So this, the nice thing about actually doing these documents, by the way, reading these documents, is that it allows you to actually look up terms in private. Right? When you start reading this, it's a new area, you might be like, what the heck is that, right? And so you want to look it up, and it allows you to save a little bit of face and maybe get a little smart on these before you start to engage your client. Next, you probably want to read your client's authorities. If you guys know what authorities are, generally speaking, they're the authority passed down, usually from the president, down to you, that gives you the authority to act and do what you need to do. And so they're oftentimes very limited, or they can be limited, particularly in the cyber realm. And so because if you get familiar with the authorities or the ROE, you are better able to actually tell the commander, hey, this doesn't meet the ROE, or this does meet the ROE. Okay, this meets the authority. Or we have to escalate this because we need to go through a different process through the authorities. Now, most likely your office has a binder with all these documents in it. If it doesn't, create one, okay, because you want to get good at understanding those things. Now you want to understand, we missed this one. I don't know what happened to that slide. So the next thing we want to understand is your, where am I at? Yes, you want to read the authorities and you want to understand your client's goal and what they want to do. All right, then we are on step 2, sorry. So next we want to understand the terminology. Now the terminology, every particular area has its own way of speaking, and you want to understand a little bit about their own language. So in cyber, we talk about things from protocols to networks to IP addresses to this TCP/IP protocol to red spaces versus blue space, encryption, private versus public key, certificates, payload, router versus switch, attack. We have the method, the mode, the path, the pattern, the signature, the surface, air gap, blacklist. You get it. It goes on and on. There's a lot of terminology. And so getting familiar with those areas can really help you start to understand what people are saying and help them explain to you how it works. So red space versus blue space, for example, if an operator starts talking about going into the red space, you should probably know what that means. And blue space is the area that the U.S. government protects and its mission partners protect, while red space is the area operated or controlled by the adversary. The next thing I want to talk about, and this is, I'm not a zealot on this, but it's something that I think is interesting, is autonomy versus AI. Oftentimes we use these interchangeably, and they are not interchangeable. Okay? AI is a subset of automation or autonomy. AI refers to the ability of machines to perform tasks that normally require human intelligence. For example, recognizing patterns, learning from experience, drawing conclusions, making predictions, or taking action, whether digitally or through smart software behind autonomous physical systems. So oftentimes the artificial intelligence is the brain of the operation of the autonomous system, but it doesn't have to be. Autonomous systems just mean that they operate with some varying degrees of human intervention. That's it, right? So your cruise control is autonomous, right? Most of them are now becoming AI as well because they're equipping AI engines in them, but they are generally autonomous. Okay? They operate with very little human interaction. We set it and we forget it. And so the autonomy just refers to anything that operates with varying degrees of human intervention, from human in the loop, actually doing it, to human completely out of the loop, what we call a fully autonomous system. So don't confuse the two and don't use them interchangeably. Now, AI, again, has its own language, right? It talks about forward chaining versus backward chaining. That's how you train it. Training the system, a neural network, which we'll talk about, deep learning, and the black box issue. As you get to know this technology and this terminology, you'll start to figure out exactly what these terms mean. It helps you become part of the conversation. We also want to keep a running list of acronyms. Anybody new to the military understands we love our acronyms. Well, that's true about other things, right? In the DoD, we have, I just used one. In the Department of Defense, we have SCI, TDYs, PCS, LES. Those are just the normal personnel ones. We've got much more complicated ones, right? In the cyber, we've got GUI, SCADA, LAN versus WAN, TCP/IP, DDoS, and IEEE, ISP, IPS, VPN, APT, OCO, DCO. I could go on and on, right? We have a lot of those. Just like the terminology, we love our acronyms. So get a running list of them, and it's okay if you have them in your book, your binder that lists all those, and you can go back and look at them. In AI, we've got NLP, NLU, DL, RPA, ML, and VA, right? The list goes on and on. Now, that said, we do have a little bit of help for you. So my colleague, Jeff Biller at the Air Force Academy, along with our new colleague, Professor Aubrey Davis, actually recently published this Air Force Cyber Law Primer, which actually does this for you. In the first half of the book, it explains, has a glossary with all these things related to cyber. Are we going to do eventually an artificial intelligence law primer? We'll see. Doesn't seem like you guys are clamoring for it. So we won't waste our time. But the point is, you have some help out there. There is help to actually figure out how this stuff works. The next thing is to take orientation courses. Oftentimes, a lot of your commands will actually have operators courses, right? So I know Space 100 exists out in Space Command. You've also got Cyberspace 190 that you can enroll in for cyberspace operations. And at the AI Accelerator at MIT, they actually offer courses as well on AI. In other words, you can enroll in these courses, and oftentimes as lawyers, they'll let you just sit in the back. You don't have to take up a seat. You can actually just sit in the back and watch them, and you can get educated on what these are. These are the entry-level courses for their operators. So you actually end up getting it dumbed down to you. It's not just something that, it's not an upper-level course. You get dumbed down to you to the point that you can understand exactly how things work. And so that can really help you save some face and start to understand the technology on a new level. Now, after you've done that, now comes the hard part. We want to start understanding the technology. We've got the terminology, we've got the acronyms, we understand the strategic documents. Now it's time to actually dive in and understand the technology by creating building blocks, by understanding the building blocks, and then potentially diagramming it if that helps you. Okay? So I'll give you some examples. So here's an example of a network, right? Many of you probably understand what a network is, but if you don't, that's okay, just go with me. And so this is just an example of what a network is. Okay, it's an interconnection of set devices capable of communicating. We've got two types of devices, right? We've got hosts, endpoints, so computers, servers, and printers on one side, and they are linked together through connecting devices, routers, switches, etc. Now they can vary in size. We can have a LAN or we can have a WAN, but the general speaking is LAN is the small area, right? So like Duke Law School has a LAN, and then the wider one is a larger geographic area, covers all of North Carolina. Okay. So this can help you sort of start to say, okay, I get how these things work together. Then, once you get the building blocks, you can start to see how the pieces work together in order to accomplish the objective. Now, it doesn't have to be too complicated, okay? This is the actual original ARPANET, so the original internet. This is what it looked like. And this is the topology of that, is what we call that, network topology of how it all worked together. You can be far simpler, okay? This is probably good, right? And it can walk you through what exactly is going on, right? You've got hosts at the top. that are connected to the internet through a router. And then down here, you've got a couple of others. So these smaller sections that not connected to the internet would be considered LANs. The whole thing in total would be considered a WAN. And this can help you figure out exactly what's going on. And once you figure that out, one thing that's missing, by the way, out of this is a modem. I don't have a modem on there. A lot of you people at your house, you probably have a modem, which is what the device that converts the incoming connection, usually a coax or a DSL, into something that you can use, Ethernet, that you can actually turn into a wireless network, or you can plug your computer in and actually work. Okay? So that's not on there, but generally speaking, these are all showing you how a system works. And if you want to extrapolate this across the board, you can, and it can become bigger and bigger, but it's the same devices overall. Then, once you do that, you want to start identifying any gaps in your understanding and research. One way you can do that is go through your topology, which you just created, your diagram, and list out potential terms that you don't understand that you need to dive into. Okay? And so we talk about, okay, what's a node, what's a network adapter, what are packets, server, router, switch, etc. Now, as I said, this is called a network topology. You might wonder, okay, well then how do these computers talk to one another? Well, they do it through the TCP/IP protocol and packets. So that's the zeros and ones flowing across. So it's sometimes nice to walk through that just to see how it works. So here's the TCP/IP architecture. It's a five-step process, 5 layers of TCP/IP. It just kind of helps you understand how the computer works. And you'll see why I'm giving this to you in just a second. So first, you start with the application. This would be like a message, if you will. It could also be your like your Safari, your web server, or web surfer. What it does is it decides to send some data, or it wants to receive data. It starts at the application level, so that's the actual software. It then sends it down to the transport layer. The transport layer, what it does is it appends the packet with more information. We call this encapsulation. So think of it like an envelope. It's going to put it in an envelope and lock up the envelope. On the top of that envelope, it's going to write protocol is TCP. It's going to write destination port. Where does it need to go? Port 80 is the web server traffic. And it's going to say where the source port came from. Where did it come from on the computer? After that, it's going to go down to the network layer where it's going to append the IP address. It's going to say here is the destination IP. Here is the receiver or the source IP. Okay, so you can come back. We then convert IP addresses into MAC addresses. Do you know what a MAC address is? Anybody? Yeah. It's the physical address, right? Every device has its own. So we do that at the data link stage. That's where it appends the MAC address. A unique one, unique to every IP addresses, can be duplicated across the world because you have LANs, right? Not WANs. But the MAC addresses are not. They are all unique. And so as a result, you end up with a longer packet. Then in the physical, it goes down, oh, I missed it. It goes down to the zeros and ones. Okay? And these are the things that are actually sent across the wire, on, off, on, off, on, off, and ultimately get to the other side of the equation. And the other, it works in reverse, going back up. Now, the reason the protocol is on there is because I wanted to chat about it for a second. So if an operator comes to you and says, hey, listen, this is what I'm going to do. I'm going to do some packet spoofing to figure out where the open ports are, and then I'm going to do some packet crafting to test the firewall, and then once I figure out where that is, I'm going to inject some malicious code, and we're going to figure out and take control of the computer. You might not know what that means, but this can help you, okay? What the operator is saying is that he can manipulate packets, or she can manipulate packets that actually change the source. So it looks like it's coming from somewhere else. So when the computer sees it, it avoids detection. So once he does that, he avoids the source. He can then figure out what ports are available so he can start going in. Once he figures that out, then he can packet craft. Packet crafting is where you actually send messed up packets and you see how the firewall reacts to it. If the firewall kicks it, well then you know, okay, they've got security there. But what you can do is by messing with the destination or the source, you can constantly avoid detection and constantly probe this particular firewall, which is operating on the host computer, to figure out exactly where the flaw or the vulnerability exists. Once you do that, then you've got your path and you can actually get in. And so you might say to him, well, great, thank you, I understand what you're saying. Now I need to go back and check to see if it meets my authorities and whether or not it meets international and domestic law. Okay? Now, I think oftentimes we might not recognize the power that these people have. So a story from my life, one time I was traveling in an airport on official duty, and I happened to be traveling with a cyber operator. And so I was sitting down, we were waiting for our plane, I took out my computer, I opened it up, I connected to the wireless network at the airport, the free one, And he looks at me and he says, what are you connected to? And I said, oh, I'm connected to the wireless network. He's like, does that concern you? I said, well, no, I don't have anything to hide. And he's like, okay, interesting. You're not connected to a VPN, are you? And I said, no, I'm not. And he's like, all right. So he takes out his computer, opens it up, and he's able to see all the networks that my computer trusts. Okay? What that means is my computer actually reaches out and says, does this network exist? Does this network exist? Is this network here? If it is, it connects automatically. If it's not, then it just says, okay, never mind, I won't try to connect. Well, he can collect that information, and then what does he do with it? He can pretend to be that particular wireless access point. And then he can connect to the internet from his. So to me, it's transparent. I look like I'm connected to that, and I get internet access. The entire time he uses a packet sniffer, he can see every single packet going over my computer, and he showed me. And it was kind of freaky. Now, that's why we should always use VPNs, right? VPNs encrypt. That's why a lot of places are going to encryption, where we encrypt from end to end. So even if he sees the packets, he has no idea what they are. Until we get to quantum computing, and then they can just de-encrypt it. Maybe. We'll see. So even times when we think, oh, we're safe, we're just in an airport, everything's good, maybe we shouldn't be connecting to free networks. And if you are, use a VPN. So when I set up my wife's computer, she has her own law practice, I said, okay, sweetie, what we need to do is we need a VPN. I don't know much, but we need a VPN. And so in compliance with the rule, I did hire an expert, and the expert came in and did all this for us. So, all right, let's talk about AI. So when we think about AI, when we think about building blocks of AI, it's probably beneficial for us to look at traditional programming, okay? If you've ever programmed before, you probably understand the basics of programming, right? What do? We take a mental model that we have of how an algorithm should proceed. We then program that into the computer through the handcrafted model, and then the user provides both the data and the model. We provide it, we hit enter, it computes and gives us a result, okay? So by way of example, let's say we want to create a program that can actually detect differences between a combatant, whether it's a lawful combatant, or whether it's a civilian, okay? An example of traditional model programming would be, we type in, let's say, 4 questions, and we say, all right, is the person wearing a fixed distinctive sign recognizable at a distance? Yes or no? Yes. Second question, are they carrying their arms openly? Yes or no? And through that, after we answer all those questions, we can hit enter, and we ultimately get a result. The result being yes or no. Okay? That's an example of traditional computer programming. And as you can tell, it's really limited to the capacity of our brains. AI flips this model a little bit on its head. What it does is it largely gives the model creation over to the computer. In other words, what we do is we take data that we know, so sample data, and then we have an expected result, we affix an expected result, and we provide that to the computer. The computer then analyzes all those results and all that data and gleans from that data a model of what the necessary things are. And then we can feed that model back into the system and with new data, and then what it can do is use the model to figure it out, okay? Now, depending how you actually create this model depends largely on which type of AI model you're using. And there are 2 main ones. The first one is machine learning, and the second one is deep learning. Deep learning is essentially just sort of an exponentially complex version of deep learning. As you see here, what we do is, in the machine learning, is we do some feature extraction. That requires a little bit of a technical capability from an individual, from a programmer, to actually look at the potential features. I'll explain this in a moment and what I mean. And then ultimately, the computer just does some evaluation of building the model based on those features that you provided it, okay? Deep learning, on the other hand, actually layers different algorithms on top of one another so that you don't actually have to do the feature extraction. It can do the feature extraction. So let's look at an example. Let's say, for example, that I wanted to go back to my example of the combatant versus civilian analysis. And a machine learning is really good with structured data. In fact, it needs structured data. What do I mean by structured data? Well, imagine like an Excel spreadsheet, and on the top it's got all these different attributes, right? So wearing a sign, carrying arms openly, red-headed, tall, right? Has all these different things. Those are the best things. I'm carrying my arms openly. So all the things, and then we have a bunch of data below it. We feed that into the computer, and what it does with structured data, it's got the feature extraction. It can tell us what things are important and what things aren't. And so it can actually tell you, all right, so this particular aspect is important. Whether they're carrying their arms openly is important. So when I do the evaluation, I'll tell you, I'm only as a computer going to focus on these 4 things. Okay? The rest of it's just nonsense. So it can help us there. It can also help figure out where the inefficiencies are. Deep learning, on the other hand, is no structured data. This is where I can literally feed pictures into it. And it can figure out what's important about the picture. It can figure out, deduce what features are important, and then from there, it can actually conclude whether or not it is, in fact, a combatant or not, right? And so in this case, the deep learning are the ones that you probably hear of. Those are the ones that are more popular. Machine learning is often used for like statistical modeling, like financial stuff. That's where it's most heavily used. You'll see in just a second, I'll talk about the models. And you'll see the deep learning is really one by itself. The other models are machine learning. And so it's a lot of evaluation of large, massive amounts of data, but it's structured data. We get to deep learning, it's all about unstructured data. And so it can tell you a lot about it, okay? Now, the idea would be that once you've created this AI, you can then put that brain into an autonomous vehicle, and it can go out and actually engage with targets. And it would be able to do it all by itself, assuming that it is of the requisite reliability. Okay. Now, some that you might have heard of before that have actually been, that have made the news. There's actually the system that they developed that could actually detect your sexual orientation. It actually came out to be 91% effective, reliable. It could actually detect it 91% reliably, whereas the best human was around the 60% mark. And so that was ultimately shut down for ethical concerns, as you can imagine. And so as a result, it's no longer in existence. Now that said, there are some issues that can pop up with AI, and so it's sometimes helpful to look at those. When we look at this particular chart, the ones on the top are things that actually exist in the training module or throughout the process. The bottom ones are the ones that we can actually suffer from an external threat. And so it starts with the data, right? So you can have data bias. I'm sure you're familiar with this, right? If the data is biased, so too will the model. And so oftentimes what we do is we use data. It's data intensive. We need a massive amount. So you're talking millions and millions and millions of records to go through a deep learning neural network. And so as a result, you need a ton of it. Well, where do we get that? We usually get that from history, right? Historical records. When we do that, what we're unfortunately doing is whatever bias we had, we are baking in to the system. And so by way of example, Amazon actually had about 100,000 applications, resumes that they had available to them, and they were way behind on evaluating all of these. So they decided to create a structure, an algorithm, an AI that could actually evaluate the resumes and then shoot out the best candidates for interview. And what they found out was that women were actually downgraded as a result. Anytime they used the word women's, for example, saying like the Women's Leadership Conference, it would actually be downgraded. They penalized graduates who were from 2 all-women's colleges, and they prioritized verbs that were more commonly found in men's resumes, like the word execute. Okay. And so after they realized this, they immediately shut it down because they said, okay, it turns out that the data we provided was biased, and therefore the results are biased. We can also have label leakage. That's where you have data, unfortunately, let's say the data is not labeled. Sometimes that can get into the system. It ultimately causes the computer to kind of go haywire. I can have label misspecification where somebody just puts in the wrong thing, right? It's a car, no, it's not, it's a skateboard. Improper and incomplete training, obviously, I think we can figure that out. There's misinterpretation of the results or data shift. So data set shift is where the new data is presented in a different way. And so as a result, when the AI looks at it, it doesn't quite know what to do, and so it will ultimately lead to improper results. Okay? But you can see at each 3 of the stages, through the data collection, through the model, and through the deployment, we can have potential issues. One thing that we do want to talk about is with what's called the black box issue. The black box issue is this idea that we're going to, largely we can see the input layer, we can see the output layer, but we don't know what goes on in between. Right, through the neural network, it's not transparent to us, it's completely opaque. And so as a result, the black box is this idea of we don't know what things the computer is relying on. And to demonstrate this, a bunch of researchers actually did the husky wolf programming. You might be familiar with this, you might have seen it. They basically tried to get a program to learn the difference between huskies and wolves. Now, to be fair to them, they were actually trying to trick the machine, so it was giving them bad data on bad data on bad data just to demonstrate that at the end it was actually reliable. You see it's only got 2 wrong, but that's, of course, extrapolated. It was about 90% effective. Then they asked the computer what it focused on. It focused on the snow. It said wolves have snow in the background, huskies, because they're pets, don't. And so it shows you that sometimes the computer can be completely off from where we think but we think it's focused on. Oh, it's focused on the nose length and the eyes. No, snow. Okay. All right, and this is just a taste of the technology. My goal for you is to dive deeper, to figure out exactly what the technology, how it operates, to take these building blocks, extrapolate, add complexity, and build. All right, step 4, we want to engage the client. Ask questions, even if they reveal your ignorance, right? When you said X, what did you mean? What can you read, or what can I read to potentially understand this capability? Do you have a sheet of acronyms or vocabulary to go to one of our earlier ones? What does it do? How does it do that? Where do you get the training data? Did you sift through the training data to determine if there's bias that exists? Have you proven the model for accuracy? How accurate is it? How do you know that? Force them to diagram or explain it to you if you don't quite get it. Don't be afraid to simply ask questions. And then here's an example of a diagram that they could use. You can also, so this is the cyber kill chain. It's just an example. There's plenty of others that exist out there. This is not the official one or anything. And then AI models. I told you I'd show there's 10 generally accepted AI models. You see deep neural networks is that deep learning, but you've also got other examples that are largely used for larger statistical analysis. And then step 5, our last step, and I think we're doing pretty good on time. Our last step, get clients to understand you. Share your world and your terminology with the clients, right? Explain Latin phrases for them. Demonstrate an interest in getting the mission accomplished and try to meet them halfway. Share an overview of bodies of law with them to help them understand what law is applicable to their operation, so hopefully they can figure out exactly how they need to start baking in this technology. Communicate with them and develop a common language so you can start to work with one another. Now, as I said in review, the point I'm trying to make, which I think I've made plenty of times, is that we need to be more technically competent. And starting at the basics, showing a little bit of humility to dive in and try to figure this stuff out can really help us be better lawyers. I think we have an obligation not only to get our advice right, but also to stay up to speed on developing technologies to be effective practitioners in this area. Now, I did ask ChatGPT for a closing. And that concludes our presentation on AI. Thank you for attending and listening to my sophisticated, intelligent insights on this fascinating topic. Now, if you'll excuse me, I need to go make sure my AI assistant hasn't taken over the world while I was talking. I mean, I programmed it to make me coffee, not conquer nations. Let's hope it got the memo.
Tim, I really have to tell you, I've heard quite a few CLE presentations, but this was not a CLE presentation like any other I've seen. This was a really educational experience, because even if you're not looking for CLE, you illustrated to us things we need to learn, different ways of thinking about these emerging technologies, and wow, what a terrific presentation. We have time for maybe 1 or 2 questions. We have a...
Also, quick announcement, the scholars, if you still have the thank you note, please continue to pass it around. We need everyone to sign that. Thank you.
David Land. At this conference 2 years ago, a senior JAG officer told prospective JAG students or possible future JAG officers, he said, don't fall in love with the soldier that you're working with or the person you're working with. Your obligation is the organization, not to those individuals. So when I looked at this and what you're saying, it almost seemed like you're talking about that for individuals, and that's something we need to recognize because I look at it, I'm the guy that pulls the trigger, drops the bomb, does whatever you need to. So I hear that you have no obligation to me. So if I ask for your advice, I've now given you information, to me, possibly confidential. Let's say I was in an actual action situation. I did something I'm a little uncertain of as to whether it might be legally correct. It doesn't matter whether it's AI or anything else. And knowing that, would I come back and talk to my JAG officer on that particular thing to ask their advice for the future? Because if I did something wrong, he may be legally bound to report that. So we've kind of created a system, since we don't have JAG officers at the lower levels, that I can actually ask for counsel and have confidentiality. How do we overcome this particular problem to get those at the bottom to actually want to use you more? Thank you.
Well, I'm going to babble here for a moment or two, and while you're getting the right answer. I think that's always been true, and I think that is something incumbent upon JAG officers to make sure that when and to include civilian lawyers, especially if you're a government lawyer, by and large, you're almost, unless you're a designated defense counsel, you are not representing the individual. And sometimes, and I think that's always important when you begin a relationship with a commander or whatever, that you do make that clear. And it's true even at the highest levels, that they need to know that you're not their individual personal lawyer. If they need that kind of advice, that's why we have in all the services now defense counsel. Which brings up an interesting point. You know, Tim's been talking about this, and thank you for the question, because it kind of reminded me that even if you're the staff judge advocate and you internalize all this, you got to make sure these days that defense counsel internalize this so that they understand for when that question does come that they're able to do it. Now, correct me.
Oh no, I thought that was a great answer. The only thing I would add, is that, and I've lost the thread. I had it, and I lost the thread. You said something. Anyway, my brain's not working. But no, I agree. I think that at the end of the day, the commander might be the person we're talking through. That's the agent of the government that we're advising. But at the end of the day, the client is actually the United States Air Force in the United States. And then I lost it again.
Well, and in the Air Force's ethics guide for lawyers, they make it pretty clear that your client is the United States Air Force.
I guess the only question I would have is I have a hard time thinking about a scenario in which this would apply, right? So if I advise the commander, here are your options, here are your left and right bounds, go, and they step out of those bounds, I find it hard to believe that they would come to me and say, but you're my attorney. I would say, well, I gave you the left and right bounds. So I don't know.
And I think he's also talking about, and this does come up, after the fact, the pilot actually dropping the bomb and is wondering, you know, did she do the right thing or something like that? And that's a defense counsel function. We have our, let the record show that our time on target is exactly right. We have hit our target. Tim, thank you so much. What a fantastic, far exceeded my very high expectations. A couple things as we bring to close this really wonderful, what I found to be a wonderful conference. Wonderful because of you all. You've made this just such a fun thing for me, and I think the rest of our team would agree, and really appreciate your support, and we hope to see you next year. A couple of quick administrative things. If you're here for CLE, be sure to sign in. Make sure that you, because you have to sign in each day. We do hope to see you next year, and if you have ideas, please feel free to convey them to me. I do want to single out a special volunteer, Mrs. Dunlap, who's had to put up with an awful lot. And for the, if the Len Scholars could stay around for a few minutes. We have a certificate for you that to memorialize your selection as Len Scholars 2023. And again, thank you so much for coming. Hope to see you next year. Thanks for giving us such a wonderful conference.